Okay, thank you.
How's the cold? You
All
dress
right.
warmly.
Say that again.
If you dress warmly and you're not cold.
Johannesburg is cold, eh? Johannesburg is cold, so but
Yeah.
it's okay. Yeah, yeah. For the last 2-3 days, one can see that we're getting into winter now.
Yes, yes. You can feel it this side as well. It's very cold.
Yeah, I'm hoping that everybody is keeping safe there, and we don't want to be affected by corona, which is on the rise now.
Hey.
Yeah.
Yeah, thank you so much. Thank you so much, Advocate, for taking your time. And we are actually recording this live, and then we will make it available on various social media platforms and also on YouTube, because at the end of the day, we want to get the knowledge for the people. So we're not just doing this for ourselves, but we want our young people especially to benefit and to be empowered with everything that we're doing. My former lecturer at the University of Zululand. He was teaching me intellectual property law, and which I loved today. I've been a tutor for IP, and I've assisted many young creatives in terms of with taking what I learned from Advocate Mwelezi and the books, and then helping them grow and becoming better. So let us all welcome on the lockdown chat with Nos and Mbuyi, Advocate Mwelezi.
Thank you so much. It's a privilege to participate in this forum, and where we will talk about issues that affect our lives on a daily basis. And especially, we will be looking at intellectual property, but we are narrowing it to copyright today. And I'm hoping that perhaps as we continue, we will look at other forms of copyright. I must also indicate that copyright is a broad subject, and therefore we are going to look at it, just a broad overview of it. And perhaps if we have time, we can then get into detailed subjects such as ownership itself. It's very important because I think ownership is critical, because this is where issues relating to who owns what, and you are employed, you are told what to do, and then the next thing you are told, no, you don't own that, the company owns it. But however, you were the one who brought in your intellectual, the intellectual property emanated from you, but who is owning? But let's start by saying intellectual property is an umbrella term, and it encompasses all various forms of product of human intellect. Here, we distinguish between tangible property, which is protected in terms of law of contracts. Then we also look at here, but however, a form of product which it comes from human intellect. Then intellectual property obviously protects various forms of rights, which copyright is one of them. Then we will basically look at shortly at copyright. What is copyright then? I think we're interested then in knowing as to what is copyright. Copyright is a form of intellectual property of already indicated. It grants the owner of the right exclusive statutory right, and it's very important for us to underline that you are granted an exclusive statutory right, limited in duration, in rendering of performance of certain dealings or acts in relation to specified work. So we will then talk, because here also we are talking, it's a protection which emanates from statute of an act of parliament. That protection is also given for a limited duration of time. We need also to know about that. Also, in relation to specified work. So in other words, there are classes of works that are protected. Of copyright it is to protect or prevent unauthorized persons from copying certain types of works. The copyright regulations regulates the law of copyright, and it specifies certain category as protected works. And we will then look at the number of works, obviously, that are being protected. Let's look at the legislative framework here. When we're talking about the legislative framework, we're talking about you must comply to certain requirements of the Constitution. Secondly, we have the Copyright Act itself of Copyright 98 of 1978 as amended, which is a very important. This legislation came into force on the 1st of January 1979. And obviously, it was subsequently amended in 2013. The Act applies not only in respect of works that were created prior to its existence, but those which were there prior to the existence. The Act was preceded by two legislations. Here we refer to the Copyright Act, which dates back to 1916 and subsequently to then 1979, as we've already indicated, which came into operation 1979. Then we want to look at we are still talking about the subsistence, duration, and ownership of the copyright in works that were created prior to January 1979 must be dealt in terms of the Copyright Act of 1965. So here it's very important. So we are saying when we're talking about duration, it's the length of time. And the length of time where that right, which is emanating from that legislation. So we are saying here, any work that came into force before January 1, 1979, it will then be created by an act which was in force in 1965. All right? So that is very important. Let's then move on. I'm not going to bother yourselves with issues relating to acts, but I want us to immediately go to what constitutes a work. What is a work? When we're talking about a work, what are we talking about? When we're talking about the work, we are specifically the types of works that are eligible for copyright. Anything which is not classified as work, as defined in legislation, is not protected. So you can see that some people will get excited, and yet whatever that, and we'll look at what, the subsistence of copyright, which is very important in terms of defining that. If the subject matter at issue does not constitute one of the types of work as provided for in the legislation, then there's no protection whatsoever. In general, a work can only be classified as falling under one type of work, and there is no overlap between. So here, why I'm saying this is because it's interesting. You're talking about music, all right? You're talking about lyrics, you're talking about notes as well. So you get two individuals, one lyrics, the other one is notes, the music itself. There's no overlap. So lyrics are protected separately from the music, or in terms of notes itself. So we will look at some of those issues. Separate aspects of particular subject matter may fall under more than one type of work. However, we have already indicated, here is a song. The song has lyrics, it has notes as well, what we call music. But however, so, it's a subject matter that we are talking about. It's one, but you can divide it, you can break it down in a number of works. Then classes of works in which copyright subsist. There are 9 specified classes of works in which copyright subsist, and we want to look at those. 1, literary works. Number 2, musical works. Number 3, artistic works. Number 4, sound recordings. Number 5, cinematograph films. Number 6, sound and television broadcast. Number 7, program carrying signals. Then we have number 8, published editions. Number 9, computer programs, and then we will then have traditional works, which are very, very important, especially for our people who are in the rural areas. The legislation will then give details in terms of defining each of that. So let's then look at, we have indicated a number of those works which are listed in the legislation, but then we want to know how does copyright subsist. So we are talking about how does it subsist. There are no formal steps such as registration. So you look at copyright is unique as compared to other forms of intellectual property which are protected under intellectual property, because almost all of them are registered, but in this one there is no registration requirement. So you cannot go to the Department of Trade and Industry and say, I have composed this song and I want it to be registered. No, that is not. So no formal steps such as registration, which are required. I've already indicated that. But however, a particular work must, however, meet certain requirements in order for it to enjoy copyright. So we want to look at some of those requirements. One, it must be a subject matter that constitutes a copyright. All right. Here, let's talk about the book, a subject matter. So, if it's not, it will not constitute that. Here is what is interesting. I take Mr. Jones, Mr. Dignity, but Tuli's work. All right, and I modify it. I then call it my work. So, will I be protected? Will that work be protected? Here are one of the requirements. That work must enjoy originality. It must reflect that the work was original. So it must not be, an extension of an existing work. All right? It must not be an extension of an existing work. It must be the product of the creator's own effort and skills. So in other words, you sat down, you thought about it, and then you created that work. So it must reflect that it is your own effort and skill. Please, I've already indicated, it should not be copied from other sources. All right, so I cannot take your work, modify it, and claim it that it is my work. So it must reflect that it is your work. Well, obviously here I've already indicated I don't want to get into what the law says, but let's look at what the courts, because the courts will then guide us in terms of what constitutes that. So the courts have indicated that the application of the author's knowledge and skill and labor must produce a result which is not merely commonplace. So it's not something commonplace that has been existing and then you call it yours. It must have a quality of individuality, not necessarily requiring intellectual novelty or innovation, but which is at least sufficient to distinguish the work from merely commonplace or that of another person. It must be apparent from the work itself that the author has made such a contribution. So you have contributed. So the standard required is not that high, but it is not capable of precise, it must be capable. If it is not capable of precise definition and showing that it is your own work, then you will not enjoy protection. So it is very important. So here we are talking about originality. So the courts also have indicated that while it is true that the actual time and effort extended by the author is of a material factor to be considered in determining originality, it remains a value judgment whether the time and effort produces something that is original. So here again, what the court are saying, it must, when you look at it, must say, wow, this thing comes from Tuli. It is his own original work, and there is nothing like that. So the appeal also confirms that originality refers to original skill and labor from the author himself. It is not just a copy of another person's work. So we are saying the requirements that material form copyright does not exist in an idea alone, it must exist in material form. Then also, we are also talking about a qualified person. The creator and the author of work must be a citizen or resident of the convention country. So there are certain countries, obviously, which have signed an instrument. If that his work will then enjoy protection by only the virtue that that person is a member of the country. So if published copies of work must be issued to the public with the consent of the copywriter in sufficient quantities. So we've also indicated that that is very important as well, that the work must be done that. Authorship, the author or creator of the work is the cornerstone of copyright. The author of work is generally the person who is responsible for the creation of his work. The person first making or creating literary work or artistic work. Person responsible, obviously, for the composition of the autograph. Then the person making arrangement for sound recording, emitting signals, obviously, of the broadcaster. So there are lots of requirements that must be met in terms of that. But what is important here is that the person must be also, the author of that work. Then we want to get into the issue of ownership. But before we talk of ownership, I don't know whether maybe we may want to have a little bit discussion in terms of the subsistence. So because subsistence is important, you cannot claim ownership of subsistence. And I've already indicated what are the requirements in as far as that is concerned.
Prof, okay, I'm just, I've just been reminded of something that you used to say, that intellectual property, or rather copyright, does not exist in a thought. You find, not
Yes.
necessarily deja vu, but you find that when you hear a certain song, you say, no, but I think I know, maybe I know this song from somewhere, So, but it's actually, you can't say that's my song, because it came in my mind first. It's all about who, it's all about who created it first. It's not about the rhythm that is the same in your mind. So that's for me, it's not really a question, but it's just a sentiment. I'm just reminded of that. A copyright does not exist in the thought.
Yeah. About that is so important. So in other words, let me just say, if you are thinking about having a baby, you cannot claim to have a baby until the baby has existed. So you can imagine having, maybe it's a boy with certain qualities, but once that boy has been born, then you can claim that. So in other words, here we are saying, let's assume that you think that your thoughts are original and they are yours. But however, you have not put them to life. Then you cannot claim copyright. Here is a song, you are thinking about that song, and then you've talked to someone. So in other words, for it to be copyright, it must be, like I've said, it's subject matter, something that you can claim as yours. It is in circulation, it is known by a number of people. You can't just say, I thought about that idea, and therefore it is mine, it is protected. It will not subsist in terms of that. Yes, it's a very good contribution.
Yeah. Nos, as a creative, what do you have any question for Advocate Mweletse?
Oh, sorry about that.
Please, okay, yeah. Now.
No, I'm just taking notes and waiting to hear about ownership rights. And so far, I'm happy.
Okay, Nos. Advocate, she has no question. Nos. Nos, can you allow me to take maybe Ulwetu, do you have any question for Advocate?
No.
Oh no, okay, that's great. Advocate, you may continue with your lecture.
All right. Now I want us to briefly talk about the ownership. All right. Ownership is a very interesting and controversial issue to some individuals as well. Just like we've already indicated that some people can claim that because they had an idea or a thought about that, you know, it belongs to them. It will not be able. We have indicated that that product will not be protected. That work will not be protected. Okay. The general rules now relating to ownership. We are saying the general rule pertaining to ownership of copyright is that the author is the first owner of copyright. All right? The author is the first. The rule is subject to a number of exceptions. All right? So in other words, there should be no dispute and confusion, because as you have written a book, and so because you are the author of that, then you are the first owner of copyright in terms of the law. But then we will want to have a look at a number of exceptions. All right? Let's look at works that were intended for publications. All right? For publications. I just want to call on the light. Just a minute, please. Right. Let's talk about the work intended for publication. Literary works or artistic work made by an author in the course of his employment. So Mr. Tuli is now employed. He's working for a company, Basize company, you know, and whilst working there, she is being requested to do some work on behalf of his employer. Now it says literary work, but please, this is only limited to literary or artistic work, what I'm talking about, made by the author in the course of his work, by the proprietor of a newspaper, magazine, or similar periodical under a contract of service or apprenticeship, and is made for the purpose of publication. The proprietor is the owner of the copyright in as far as the work is concerned. So you can't say, I mean, I will go seven. So I was in the work, and this being echo, you know, this is my effort. It's because of my effort, my skill, and as I've already indicated. No, the law indicates that will then, you know, ownership will then be ownership for your employer. A distinction is drawn between the author of work and the owner of copyright therein. The maker or creator of the work remains the author of the work. But however, the proprietor of the newspaper or magazine will then be the owner. All right? So here, remember that when we were talking about the subsistence, we talked about the author. So you remain the author, but we should be able to distinguish between an author and the owner. All right? Here we have said the owner, in terms of this, is the proprietor. The proprietor is the owner. But because you were employed there and you produced the literary work or the artistic work, here it's an art that is beautiful. All right? You have produced it. So on that art, you can write your name perhaps as the author. But the owner is the proprietor. Okay? So That's where the difference is. The exception only applies to the extent to which literary or artistic work is created specifically for publication, and this is for a newspaper or a magazine or a similar periodical. All right. So let's say, like Mweleti. Can Mweleti, who has requested you to produce some art for him, claim ownership? No, remember that Mweleti is not the, Mweleti is not owner of a newspaper or a magazine or a similar, periodical. And therefore, this is only, the exception is only limited specifically for publication in newspapers or magazine or similar periodicals. The author is both the owner and the author if the work was not created for publication in a newspaper, or like, for instance, publication in collection for short stories, including some of the films. So let's just say now you are writing a short story. You are an author for that. Then as an author, it belongs to you because you are not writing it, for a periodical or for a newspaper. You are not employed. It was just for, let's just say you write and then you take it, you want it to be published and it is published, it is yours as an owner. But let's say you are working for a periodical or for a newspaper and the newspaper says you must write an article on behalf of that newspaper. That article, that art or article belongs to the newspaper. It does not belong to you. So that this is where we need. Then let's look at, now this is where Mweleti comes, says, can you produce an art for me and then I will pay you for it? All right? So here is specified work created for payment. Where a person is commissioned to take a photograph, for instance, the painting or drawing of a portrait, the making of a gravure, the making of a film, or the making of a sound recording, and pays and agrees to pay for it in monies or money's worth, and the work is made in pursuance of that commission, the person who commissioned the work is the owner of the copyright. Of the copyright is the person who commissioned the work itself. The exception here also applies to photographs, portraits, gravures, films, and sound recordings. Please note the following: the exception does not apply to artistic work such as paintings or drawings or other portraits. All right. So here we have said you are taking pictures, you are doing, some painting, or you are drawing a portrait for me. So we have asked, who is the owner? Because I'm going to pay you here. I'm going to pay you for that work. Obviously, once you have done the work, because I have paid, there's money that have exchanged work, then that work will then belong to the person who has commissioned that work. All right? And remember, we've already indicated that this exception is important, but however, the exception will not apply to artistic work in general, such as painting or drawing, other than portraits. Then let's talk about employer and employee relationship. Now you are employed, okay? This exception is not the same as that where we're talking about the proprietor of a newspaper or magazine. Remember that we talked about the proprietor of a newspaper or magazine for literary work, or artistic work. But here we are talking about you are now employed there, where the work is done in the course of the author's employment by another person under a contract of service or apprenticeship. The author is the owner of the copyright. Okay, the author is the exception extends beyond, obviously, the literary work here. But also, let's also look at, we've looked at these exceptions which have been created by law. It is also important that there are contractual arrangements that are allowed by law when it's coming to the, to ownership. So we can enter into some contractual arrangements, and therefore, where the parties have entered into, some contractual arrangement, the sanctity of a contract obviously will then be upheld, because the courts will then respect the contractual arrangements between the two parties.
Advocate.
Yes.
So sorry to disturb you. I'm just looking at time. Can we throw in questions right now, because I think we've got 5 minutes left.
That's all right. Okay.
Okay. I want to ask about, okay, let's say there's a work that I'm doing after work hours. Now that work probably I'm doing, okay, let's say I'm employed by Isolezwe newspaper, and then I get to do some of the work writings when I'm at home. It's after work hours. Who is the owner? Is Isolezwe the owner of that work, or I am the owner of that work because I was working after work hours?
Okay.
That's the question I have.
Let's say we remember that we are talking about literary work and artistic work. The limitation in terms of, the proprietor, owner of it is only in respect of those. Okay, fine. The first thing is what I've talked about, contractual arrangement. What does the contract say? All right. If the contract says we exclude any work that will do outside, working hours, then that will then belong, obviously, I've already indicated, then the court will then honor the contractual arrangement. But however, if you are employed and your job description indicates that whatever that you are doing after hours is part of your job description, because you are employed to do that, that work will then belong to the proprietor. The proprietor is the owner. You cannot claim it as yours. But let's assume that you are employed by a magazine, you are in the finance department, and yours is to do finance, and has nothing to do with literary or artistic work. All right? And then you produce that work, then the work will then remain to you. The proprietor may not claim it as his work. So like I've said, what are the contractual, and then more importantly, what are you employed to do?
My question is, and similarly, but now on social media platforms, because now
yes,
doing a lot of work and they're producing either artworks, publishing literature online. So on social media platforms, what are the ownership rights on that when people copy and share somewhere else?
Yes, for instance, ownership, even if, okay, let's just say you do some work and then you post it on the social media, that work will then belong to the proprietor, because you are employed to do so. Remember that we have said, if made by the author in the course of employment by a proprietor, which is a newspaper, magazine, or similar periodical, and then it is posted online, then the proprietor is the owner, or the magazine, owner of the magazine is you cannot claim it as yours.
Even, okay, I'm thinking, even if it's your personal account and you're not doing it through the website, it's not through their website.
What is? Okay, I've already indicated that, by the way, there's a conflict of interest, because what you are doing is, you are doing basically what you have been contracted to do by your employer or by the proprietor. You are now doing it online. There's a conflict of interest, and then that is likely also to, remember that we are saying here, we are protecting the intellectual rights. What is intellectual property? Intellectual property is to protect the money that the proprietor may enjoy. All right? So the proprietor has employed you to do that. You cannot do that outside your employment, do similar things that would have been done, on behalf of the employer, and indicate it is on social media and therefore it belongs to me. All right? So the proprietor is protected by copyright, even on what will be on social media.
Yeah.
Unless if there are contractual arrangement that says no.
No, that is very clear, advocate. I see now we've got 30 seconds to close. Yeah, but thanks so for joining us, advocate. Thank to everyone who attended this Zoom meeting. We are also joined by, I'd like to also acknowledge Mr. Sbia, who also joined us. He's also a lecturer at the University of Maryland, and we have other people who are also joining us. And thank you so much.